on the other side, and we'll be waiting to you. So let me speak today. The rest of this person. We just want to give free motive to anybody, unless they're willing to take the law.
My response is contained in the affidavit filed by the ODPP. It's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I also proceed in response to the substantive application,
must be direction in the objection. I remind that once more, I belong to the law on bond and bail. Avoid instances which may persuade me to request the fact having evidence from your end.
I am well.
Which will render you in a very awkward position.
I am well. Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
After every sentence, you have to
And there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmations in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here. The argument that the intended witnesses are subordinates to the governor, the accused person, witnesses are subordinates to the governor, the accused person, Again, it is not contained anywhere in the affidavit.
Amounts to a permissible limitation of a right and Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you, protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. We are releasing an accused person on bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason, to deny them bail. Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akula.
And we have filed an affidavit sworn on 19th May 2025 by Mr. Robert Brown.
Sworn
19th of May 2025, this morning. Sorry, yesterday, Your Honor.
that is very good.
Yes, for Your Honor.
19,
We filed this morning.
5, and 5
Yes, Your Honor. Your Honor, it is sworn by Robert Brown.
Sworn by
Robert Brown. And ESCC Forensic Examiner. There are the factual reasons or grounds to reject bail are defined from paragraph 1 to paragraph 12. However, I will cluster them into
paragraph
three,
1.
1 to paragraph 12. And however, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations which at paragraph 3 and 4 confirm paragraph 4 of the affidavit, confirm that the accused person, through his agents,
confirm that
the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38 at Kitale Police Station. R38, PR38, annexure PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. And my objection, Your Honor, is founded on section 106B of the Evidence Act.
that is your name.
Willis Otieno, counsel for the first accused. Section 106.
Minute. Yes,
Section 106B
on electronic evidence.
on electronic evidence.
You get your time.
No, I wanted to raise an objection because it's time to refer to it.
You get your time, let it continue.